Dear guests, I welcome you to this conference on sexual violence and survivor-centered justice. My name is Irma Ellingsdóttir, and I'm the director of RIKK, Institute for Gender Equality and Difference, here at the University of Iceland. In organizing this conference, we had the good fortune to work with excellent coordinating partners. I would like to thank specifically Professor Ulrika Andersson and the Law Faculty of Lund University and Professor Malin Skilbre at the Department of Criminology and Sociology of Law at Oslo University for their contribution. I would also like to thank the sponsors of the conference, the Icelandic Gender Equality Fund, the Nordic Council of Ministers, and the Icelandic Prime Minister's Office. Their support has been crucial in bringing us all together here today. Last but not least, I want to extend my thanks to my dear colleagues Hilde Fjóla Antonsdóttir, a postdoctoral fellow at the EDDA Research Center at the University of Iceland and the instigator of this conference, as well as Elín Björk Jóhannsdóttir, a RIKK project manager. Both have been instrumental in putting this conference together. The idea behind it is to think how we can further the justice agenda for victim survivors of sexual violence. Traditionally, the meaning of justice for such victims has been tied to criminal justice, that is, a conviction of the perpetrator in a criminal court. At the same time, however, we know that such convictions are rare and reflect in many ways the justice deficit that characterizes these cases, not only in Iceland and the other Nordic countries, but around the world. We also know that the meaning of justice for many survivors of sexual violence is much more complex and nuanced than captured by conventional criminal justice. Therefore, the aim of this conference is to contribute to thinking about how to better meet victim survivors' justice interests by exploring the potential of different justice paradigms, mechanisms, and practices. For this purpose, we have invited outstanding scholars who have thought about these questions in relation to different justice pathways, such as administrative and labor law, tort law and compensation, criminal law, and restorative justice and transformative justice practices. In Iceland, we have seen an increasing focus on the question of justice for victim survivors of sexual violence, especially as a response to the Me Too movement, which has had a significant impact on Icelandic society. This has led to numerous legal and policy debates, some of which have led to legislative changes. In 2018, the Icelandic Parliament changed the definition of rape in the Penal Code to include voluntary consent in line with the Istanbul Convention. This year, important changes were made to the Code of Criminal Procedure to strengthen the rights of victims of rape and other serious crimes in the criminal justice process. Also, this year, Parliament enacted a new law that defines victims of sexual violence and intimate partner violence as a special category, allowing them to apply for legal aid from the state to pursue tort lawsuits against offenders. The bill will come into force in 2023. Moreover, according to the current government coalition agreement, work is underway to explore the use of restorative justice practices in cases of sexual violence. The Me Too movement continues to impact Icelandic society. Survivors of sexual violence and harassment speak out in the media and particularly on social media and are increasingly naming offenders publicly. In February this year, it was revealed that over the course of the last 12 months, at least 31 influential men who have been publicly named and accused by survivors of indecent behavior, harassment, gender-based violence, or sexual violence, have resigned or been discharged from their positions, have been refused positions of responsibility, had their events cancelled or been blocked from participation in sporting events. In other cases, however, alleged offenders have threatened and pursued defamation lawsuits against their accusers and their supporters. The socio-legal developments indicate that criminal justice might be losing its dominant position in the imaginative space of justice in cases of sexual violence. Instead, we are seeing the proliferation of different justice paradigms and pathways. It is, therefore, important to gain a better understanding of whether and how these mechanisms and practices can meet the justice interests of victim survivors. Moreover, it is important to ask, what are the possible implications of plural justice agenda for victim survivors of sexual violence? And how can we conceptualize the relationship between the criminal justice system and alternative justice paradigms and processes, whether they are compatible or not? I know that these questions are some of the important questions that will be addressed here today, and I wish you a fruitful discussion. Thank you. Hildur Fjóla, the floor is yours.
Thank you, Irma. Dear guests, welcome to this conference. As Irma mentioned, we've been waiting to host this conference for a long time now, and we're delighted to have all these excellent speakers with us. So my name is Hildur Fjóla Antonsdóttir, and I'm a postdoctoral researcher at the EDDA Research Center at the University of Iceland, like Irma said. And I have the honor of chairing the conference today. So we have a long day ahead of us, but before we start, I would like to briefly go over the program. So the conference has 5 panels on different justice pathways from survivors' perspectives, after which we will end with a plenary session with a discussion of some of the broader implications of a plural justice strategy in case of sexual violence. So each panel is 75 minutes in length and includes 3 speakers. Each speaker has 15 minutes for their presentation, and then we should have about 20 to 30 minutes for questions and answers after. We will be taking questions from the audience, of course, and recordings from the conference will be made available afterwards. We will have 15 minutes breaks between panels, and we'll be serving coffee outside the lecture hall, as well as some snacks. And of course, we will also have a lunch break, which is between 11:30 and 12:45. And we ask you not to bring food or drinks in open containers into the hall. So, without further ado, we will start our first panel, which is on the topic of administrative justice and labor law. And I will hand over to Linnea Wegerstad. Please, Linnea. Linnea is a senior researcher at the Department of Law at Lund University. So please, the floor is yours.
Okay, so I'm going to sit here, I think. Okay, do you want to, is it okay with you to sit there, or do you want to join me up here? How do you... What do you feel like? You prefer to? You just choose. Yeah, okay, okay. Okay, so you want to stand there? Yes. Okay, I sit here. Okay, so thank you so much for inviting me to chair this session. about administrative justice and labor law. And first out is Vanessa Munro, Professor of Law at University of Warwick. So I give the floor to you for this. And I will use signs.
Perfect.
To keep track of time.
That's a very good idea. Okay. Well, first of all, thank you very much for the invitation to present. I'm delighted to be here and very much looking forward to today's discussions as they unfold. I've been asked primarily today to talk about a topic that Sharon Cowan, over there, and I published an article on last year in the Journal of Law and Society, which was to do with what we identified and called a criminal justice drift in responses to student-on-student sexual violence and misconduct in UK university complaints processes. It feels a bit strange to kind of solo present this co-authored paper when Sharon's right there, but the benefit of that is that when you ask me difficult questions that I can't answer, I can point to Sharon and she can have a go instead. And I also want to just quickly also acknowledge the role of Claire McGlynn, who's here too, because she was involved in a number of kind of the early conversations that the three of us, me, Sharon and Claire, had around this topic, which really inspired the article that it evolved into now. So my presentation today is broadly divided into three parts. In the first part, I want to just try and briefly set out the empirical and kind of regulatory scene in relation to student sexual violence and misconduct in the UK. Having done that, I'll say a little bit more about what Sharon and I referred to as this criminal justice drift, some of the problematic ways in which we think it's manifested itself thus far and where it's kind of coming from. And then in the third section, I'll say a little bit about what we think has been pushed aside as part of that process and the ways in which the influence of criminal justice has not only imported harms into the disciplinary process, but also kind of eclipsed the possibility for different, more campus-oriented responses. So, in some countries, there's extensive data available about the prevalence of sexual violence and misconduct in higher education. That's not so much the case in the UK. We don't have a kind of robust national survey or data set. And universities don't routinely survey and publish data from their own student populations. But of the research that does exist, it's clear that this is a significant issue. In 2011, for example, the National Union of Students published its Hidden Marks report, indicating that during their time as students, 1 in 7 female respondents had experienced serious physical or sexual assault. 68% had been subjected to harassment, including groping, flashing, and 16% had experienced unwanted kissing, touching or molesting, often in public spaces in and around campus. In 2014, a follow-up poll indicated that 37% of female students and 12% of men had experienced unwanted sexual advances during their time at university. 62% said they'd heard jokes about rape or sexual assault on campus. A survey in 2018 of over 4,500 students from over 150 different UK institutions found that 62% had experienced some form of sexual violence whilst at university, with the figure rising to 70% for female respondents, but only about 6% of them had reported that to the universities, broadly in line with about the same percentage reporting to the police. And all of that kind of corresponds to data from the Office for National Statistics in England and Wales, which tells us that full-time students are more likely to experience sexual victimisation than any other occupational group, with factors to do with race, disability, sexuality and ethnicity all intersecting to create different exposure to that risk. So in the face of that kind of growing evidence base about the scale of sexual violence perpetrated by students on students within UK university communities, there's been increasing pressure on institutions to develop more robust responses. On the one hand, students reporting sexual violence have denounced publicly investigative processes that they thought excluded them or caused them additional harm or didn't sufficiently recognise the severity of the harms they experienced. On the other hand, those accused of sexual violence have complained that university processes aren't fit for purpose and that they're not receiving adequate protections in the proceedings. In both cases, that's led to a string of national headlines and high-profile student protests on campuses. Not surprisingly, given the market-oriented nature of higher education in the United Kingdom, institutions have become increasingly anxious about the reputational damage tied to those kind of high-profile complaints. And in tandem with that, what we've also seen in recent years is a marked change from sector regulators. So from a position in the 1990s, where UK universities were advised not to investigate serious criminal matters and certainly not to engage in any kind of response through disciplinary processes to allegations of sexual violence unless and until a criminal investigation had been completed. In 2016, Universities UK published its Changing the Culture report, which represented a very definite change of position. It imposed an expectation on all institutions to adopt a zero-tolerance approach to sexual violence, which was to be supported by initiatives to reinforce positive behaviour on campus and to establish disciplinary processes for investigating and sanctioning unacceptable conduct. That kind of approach has since been cemented by other guidance from the sector regulators, but we're still in a position where all of that guidance leaves considerable discretion in the hands of individual universities in terms of how they interpret those expectations. And it's fair to say that practice across the sector has varied markedly. There's also evidence of pretty significant attrition through the process as well. So freedom of information requests made between 2017 and 2022 revealed that across 125 UK institutions, there were just over 1,400 recorded rapes of sexual misconduct made by students, of which just under 500 were investigated and just over 200 resulted in disciplinary proceedings being commenced. So it's fair to say then that there are kind of ongoing concerns about the adequacy of responses to complaints of student sexual violence and misconduct in the UK higher education sector. And those concerns relate variously to the resourcing of consent training and bystander initiatives, the availability of specialist wellbeing support on campus, the adequacy and clarity of codes of conduct, the relationship between formal and informal reporting mechanisms, and also the suitability of those investigative and disciplinary processes when formal complaints are made. None of those concerns stand in isolation, of course, but in the article, Sharon and I wanted to focus our attention particularly on the last of them, namely that disciplinary process. And we argued that in the midst of this kind of institutional anxiety about how to develop appropriate and appropriately robust responses, UK universities were increasingly borrowing familiar frames from the criminal justice paradigm. The context here is patently different. Codes of conduct in the university sector have different behavioural standards attached to what counts as misconduct. They have different standards of proof, requiring just balance of probabilities rather than beyond reasonable doubt. But nonetheless, university processes have increasingly mirrored many of those kind of adversarial trappings and evidential standards of the criminal justice approach, all the while positioning the person who makes the complaint in the same kind of third-party status as they would have in the criminal justice process. So the complaint is between the institution and the complaint against student, with the person who makes the complaint there merely as a witness in that process. Universities have also increasingly contracted out the investigative process to external stakeholders, many of whom have backgrounds in criminal justice, most often retired police officers. And that has led to some high-profile cases in which reporting students have been asked in detail about their behaviour or their sexual history, notwithstanding its prejudicial effects and notwithstanding the fact that it was ostensibly entirely irrelevant to the complaint that was under investigation. In addition, there's also been increasing acceptance of legal representation for reported against students during university disciplinary hearings. In the recent decision of AB, for example, a student had been expelled from their university after a disciplinary hearing concluded that he had non-consensual sex with a fellow student who was intoxicated to the point of appearing to have passed out. Rather than appeal against that disciplinary decision, this student brought legal proceedings for breach of contract against the university on the basis that the university's stated policy did not allow legal representation during the disciplinary hearing, and that contravened the rules of natural justice. At the initial trial, the judge was unpersuaded by that and noted, quote, it wouldn't be appropriate for a you're about to give me that, aren't you? It wouldn't be appropriate for a disciplinary hearing to become lengthy and legalistic. But at the full hearing, the High Court took a rather different approach. It accepted that there was no right to representation simply because this was a disciplinary matter, and somewhat controversially, given what we know about the consent standard in criminal law, the judge considered that consent is a relatively straightforward concept, so it wasn't likely to give rise to difficult questions of law. But nonetheless, they concluded that this was a very serious allegation and the loss of benefit to the student was significant, and so therefore increased protection in the form of legal representation was appropriate. The court accepted a kind of potential chilling effect, as they described it, in terms of deterring complainants from coming forward. But they concluded that, quote, the dangers of that shouldn't really be overstated and could be managed by effective chairing of the university disciplinary committee, note by university personnel who wouldn't necessarily have great experience in the terrain. This, of course, fails to acknowledge that existing evidence base about substantial underreporting of sexual victimisation, often precisely because of a fear about legalistic and adversarial processes. And it also underestimates the difficulties of managing a one-sided dynamic where one person in the room has legal representation and the other doesn't. In fact, it also, we suggested, highlights the kind of overall one-directional trajectory of travel of this criminal justice drift. So on the one hand, you have arguments about natural justice being leveraged to increase adversarial processes, increase legalistic intervention in the interests of the reported party, but they're not being leveraged in the same way in relation to the interests and protections of the reporting party. For example, there's no discussion there about thinking about alternative modes of testimony giving, remotes or use of screens. There's no discussion there about whether natural justice would require containing the types of questions that could be asked during those proceedings. The court and AB were quite insistent that they weren't setting a precedent in that decision, but the reality is that it's hard to imagine many universities are not going to have at the back of their minds the risk that their disciplinary outcomes will be set aside by lengthy court processes if they don't allow legal representation for the reported against party. I've only got a couple of minutes left, so I'm going to scoot through the last bit. So in the article then, Sharon and I are critical of this criminal justice drift because we think it replicates some of the problems of the adversarial criminal justice process, and because it fails to consider the ways in which natural justice requirements need to be looked at in terms of what would a genuine equality of arms look like in this context. But we were also critical of it because we kind of felt like it eclipsed the potential for alternative ways of thinking about and responding to the issues. And in particular, we felt it failed to take sufficiently seriously the legal and ethical duties of care that universities owe to all students in their communities, including entitlements to equality of access to education and access to safe campuses. So we drew on Claire McGlynn's work with Magda Forgalska, which identified that students who report to UK universities do so for a wide range of reasons. A punitive sanction might be one of those objectives, but so too might being able to navigate their campus safely without fear of encountering the perpetrator. So too might education to ensure that others, including perpetrators, recognise the harm that was done to them. And those kind of interests are often too complex to be responded to effectively within a criminal justice framing alone. Universities, we suggested, have it in their power to create new opportunities for that recognition. That might be, for example, by creating alternative and more trauma-informed spaces in which victims can narrate what's happened to them. It might be intervening to manage campus spaces to enable safe access without the fear of bumping into perpetrators. Or it might be mandating all students to engage with really robust consent and sexual ethics training. And the final point that I just make is that one of the other issues with the criminal justice drift, and this is something that Sharon and I have been thinking about more recently as part of a new bit of work, is that it also runs the risk of kind of producing ancillary harms. And one area where we can start to see that happening is around issues about disclosure of the outcomes of sanctions. So there's a lot of debate at the moment in the UK sector around whether or not the outcomes of disciplinary processes can or should be disclosed to the parties and to the student community more broadly. And the Universities UK have recently produced this guidance where they've acknowledged that to date, institutions have been pretty risk averse about that. And they've said, actually, we would like you to look at these things on a case-by-case basis. The difficulty, though, is, again, they don't give a clear mandate to universities to say you should disclose this information. And so what you have is a kind of criminal justice drift where people are using the language of finding individuals guilty of offences. That's not what this is, of course, but what that does is it leverages, so you get this sense of a very weighty ramification of the sanction for that individual. And then when you weigh that in the balance, decide about disclosure, there aren't accompanying mechanisms to recognise the harms to the other parties involved, be that the victim in the process and beyond, or wider campus communities and the legitimate interest that they might have in knowing that where misconduct occurs, that it is dealt with and it's dealt with appropriately. And you're waving your pen at me, so I will stop there.
Okay, so our next speaker in this panel is Professor Ulrika Andersson from Lund University, Sweden.
Kan du ta? Okay, nu ska jag se om jag klarar det här. I just go further. I just move like that. Do you want this more? Is it too long? No, it's okay. It's okay. It's okay. Thank you so much, Linnea, and thank you so much, Hildur Fjola, for taking this initiative. And Elin and everyone else making this work really well. It's great to be back here in Reykjavik. It's actually my third time here, and the first time I was here was also at a conference about law and gender, ages ago. So it feels great to be back. I have a background in criminal law and law and gender, and I'm currently running a project with Claire McLean and Linnea, who is presenting later. But I'm also, we're doing a project on the Me Too movement, on legal and societal responses after the Me Too movement. So, but I'm also in a project about sexual harassment at Lund University. And together with my colleague Tuva Bennett, I'm currently doing a study on disciplinary sanctions, cases about disciplinary sanctions on sexual harassment between students. So this is a current study, so I will not go into any details, but I will say something about our very preliminary findings. But I will also introduce you to the Swedish system on disciplinary sanctions at universities. So I will say something about the background of the study, about the demand for responses. At the moment, I will go into university responses in Sweden and about this ongoing study on disciplinary sanctions at Lund University and some preliminary findings. So the background of the study, I would say, is actually the Me Too movement. It's clear that after the Me Too movement, a lot of employers in Sweden and worldwide, including universities, wanted to take action against sexual harassment and sexual violence at university. And in Lund, this led to that the vice chancellor appointed the tellus. We say tellus, but it's tell us, because the university wanted its employees and students to tell about sexual harassment. And with the aim to strengthen the preventative work against sexual harassment, plan for a long-term and sustainable process, work in a knowledge-based manner, and make use of the resources available at Lund University, and to have an open dialogue. And I'm part of that project, and I'm also part of a research project related to this. And according to a survey that was handed out to all employees at Lund University, all students and all doctoral students, I will not go into that study at all, but according to that recent survey, 27% of the students were exposed to some kind of sexual harassment at Lund University during their time of studies at Lund University. And actually, most of them were exposed by another student. More than 80% were exposed by another student, which may be a bit, which could be seen as a surprise. So, as I was saying, I would say, and what Vanessa was talking about, there is a growing demand for adequate responses to complaints of student sexual harassment and violence also in Sweden. And we could see this was among the students in the free text answer in that survey I was talking about. A lot of students wanted the university to act more, to respond more to what was happening, and also to respond in a harsher way. And this is, you can interpret as a way of, in line with a repressive turn, so to speak. This is what's in all of society. But also, I would say there is a demand from management at universities themselves. They want to take care of the problem, so to speak, and they want to act harsher. I think that's what you can see. And also a detail, but there is a recent parliamentary report in Sweden proposing a widened scope for expulsion, so that it could be easier to expel students. But we'll talk about that, not about that report, but about the procedure for expulsion in a minute. So basically in Sweden, there are two kinds of disciplinary systems, you can say. And they are the university disciplinary boards at each university. So there is a local disciplinary board, but it's regulated in the whole of Sweden. So it's in the higher education regulation, it's regulated. So according to this, the institutions at the universities are obliged to report to the disciplinary board at the local university, to the local disciplinary board at the university, if there is a reasonable suspicion or well-founded suspicion of, for example, sexual harassment. I need to say that these disciplinary boards are mainly dealing with plagiarism and cheating, and not that many cases of sexual harassment. But they should act. And yes, what they can do is they can warn the students, and that's basically saying in a decision that you have done this and that, and we warn you. And then they can suspend the student from that university from 1 to 6 months. The average is 2 to 3 months, I would say. Yeah, so that's I can say. So that's the one of the systems. The other system, which I think it's quite rare if you look in an international context, is that there is the Higher Education Expulsions Board. And that's a central board situated in Stockholm, dealing with all universities in Sweden. And it's not an appeal board. It's when the vice chancellor at a university refers a case to this board. And it's not dealing with many cases, maybe 3-4 cases a year. But the big difference, I think, compared to, for example, UK, is that when they decide about expulsion, you're expelled from all universities in Sweden. So that's quite a heavy sanction. And you're expelled from one or two educational programs, for example. It could be medicine and the nursing program, depending on what has happened. And it is for 1 or 2 years. I think it can't be long, I'm not that sure, but what I've seen is mostly 2 years. And then, in some cases, there is a possibility to do a renewal trial, to see if the conditions are still there. So I will tell a little bit more about the requirements in a minute. But so these are basically 2 different reactions. It's important to state, because the disciplinary boards, they have disciplinary sanctions, and they are reacting towards sexual harassment or other unwanted behavior. So that's a sanction. But the Higher Education Expulsions Board, their decisions are explicitly told to prevent students from harming their environment after a report from the Vice Chancellor. And a little bit more about the requirements then. The disciplinary boards, they have to act, as I said, the institutions have to report to the disciplinary boards if there is a well-founded suspicion of sexual harassment. And sexual harassment is then defined in the Discrimination Act, or the Non-Discrimination Act, Chapter 1, Paragraph 4.5, and it's defined as a conduct of sexual nature that violates someone's dignity. So it's a really wide definition. And this can be, for example, comments or words, groping or indiscreet looks. It can also include unwelcome compliments, invitations, or suggestive acts. And of course, severe incidents such as rape are also included here. So that was what the boards has to deal with when it comes to sexual harassment. If you then look at the Higher Education Expulsions Board, they have to try and assess if the student suffers from a mental disorder or abuses alcohol or drugs, or the third bullet point, which is current here, the student has been found guilty of a serious crime, but that is not enough. Then you have to decide if there is a clear risk that the students will harm another person or cause substantial damage to property during the course of his or her studies. So in relation to sexual harassment is the third bullet point. It has to be a serious crime, and there has to be this risk. So it's not very often that this sort of expulsion is taking place at all, and not in relation to sexual offences. 5 minutes, okay. Okay, so I will tell you a little about now this ongoing study. And as I said, my colleague Tuva Bennett, I don't know if I said her name, we're doing this small study. We have collected decisions and act material, including communication to the parties, in 15 cases from 2000 and 2020 that are related in some way to sexual harassment. And those are all the cases from those years at Lund University. So not very many cases. And I don't think I said it, but you mentioned it, Vanessa. Most of the students, according to our survey, as well, confirming what you were saying, do not report cases. And that's in line with other studies as well. So what we study then, among other things, is what cases are reported to the board, what sort of cases, what sort of sexual harassment, and how does the disciplinary board argue. And I want to stress now, these are really very preliminary findings. But it's interesting, but before I read your article, Sharon and Vanessa, we had the same feeling that this system is mimicking the criminal justice system. So we find that in the disciplinary board turns to the criminal justice system, and signs of this is the language that they use. Very often they use beyond a reasonable doubt, and they use terminology from the criminal justice system. He says, she says, ord mot ord situation in Swedish. That this is a he says, she says situation. They use principles that I'm not sure. I have did a bit of search there in the doctrines, and it seems to be unclear whether these principles should actually be related and be current in this system. For example, res judicata, which is, when there is a case is already decided upon, they refer to this principle to dismiss cases, for example. And to my knowledge, I'm not sure that this principle should be in this administrative system, but I will have to dig into that more. So the language that the disciplinary board is using, the parties themselves obviously perceive this as an adversarial procedure. For example, they ask for legal representation, and in one case, the disciplinary board was rejecting that. Then I'm about to finish now, so that's good. That I have 2 minutes. So basically, this turn to criminal justice system is creating justice gaps, if you will, in mainly 2 different ways. We have seen, this is very few cases, but still there is a tendency that in the less severe cases, the disciplinary board find that this is not proven or this is not styrkt. So there is no sanction. I'm not saying that in all cases, but there is a tendency. But in the severe cases, on the other hand, the board refers the case to the criminal justice system. They say, this is too difficult for us to handle. We are not a criminal justice, we're not a court. So you should go to the criminal justice system. And so that was in one case. In another case, which was a very high-profile case in Lund, where there was a student, he was actually convicted of rape, so there was a verdict, and then the vice chancellor directly referred the case to the Higher Educational Expulsions Board, and I interpreted this that they wanted to give a statement. They wanted to show that we are acting, because if the lawyer said he's not going to be expelled. But still the vice-chancellor wanted to, act. And so they immediately referred the case to the Higher Education Expulsions Board without acting as a disciplinary board. So I found that really interesting, because to what I understand, that would have been possible too. You could have done both. But they didn't act, and they didn't report to the disciplinary board. Instead, they referred it to the Higher Education Board. But the student was not considered to be. There was not a clear risk that he would be dangerous. So that was. So he was not expelled. And again, I will finish. Again, they did to refer to what to Claire's work and to what you have been saying here. They were actually working so that the students around him, the other student, the complainant, so to speak, could study separately from that guy, and that also he was separated. But he could continue. Okay, so I'm finishing now, but please note these are very preliminary findings. So thank you so much.
Okay, thank you so much, Ulrika. And our next speaker is Maria June Bjarnadottir, Director for Internet Safety at the Icelandic National Commissioner of Police.
Okay.
Do we have a...
Yes. My apologies in advance. I didn't send the slides in time, so this is my fault. And I feel that not everyone is happy with me.
We are happy that you're here.
No, okay, this doesn't fit. I will just describe the images to you. It's absolutely fine. They are amazing anyways. So hello, my name is Maria Bjarnadóttir. I am here in a personal capacity, not as a representative of the police, where I work from 9 to 5, usually. So I'm here, but of course this is informed by my work for the police as all other work that I do. I'm just going to move this. Thank you. So what I wanted to talk about is a little bit away from the university framework and more into the general workplace. And my title is Reframing the Response to Sexual Harassment in the Workplace. And that is somewhat informed by what has happened here in Iceland after the Me Too movement and the call for responses that maybe do not meet the responses that the legislation provides currently. So what we have here in the gender equality paradise are a number of legislations that deal with sexual harassment. We have the criminal standard, of course, in the criminal code. We have the Equality Act standard that was recently revised in 2020, and we have the workplace regulation that is connected in a way to the Equality Act. These standards are, of course, as has been described, not similar, or they're similar but not the same. So the criminal standard, of course, holds the framing of the criminal system, whilst the Equality Act and the workplace regulation do not. They are more as what we have talked about here as the university framework. So the Gender Equality Act was reformed in 2020, and everyone that, of course, has followed the Me Too discussion knows that this means post-Me Too. And in my opinion, and not the opinion of the police, I just have to say this, I think that we missed an opportunity when we reformed the Gender Equality or the Equality Act, by not addressing the gaps and overlaps in the way that the Equality Act and the workplace regulation intertwine. And I say this with utmost respect. I think it's a brilliant act in many ways, but in this respect, I think we should have done a little better. And the act, of course, is, I mean, in many ways important. It's a shift from the binary approach to gender, which is commendable. It sets up for a new complaints committee that unfortunately has not been used as much as I think it should be. And I think that would be a brilliant way for us to test the legislation by sending more cases to the administrative, the complaints board. And it also amended the definition of sexual harassment. So what was done was that the prior legislation called for sexual harassment under the Equality Act, or the former Gender Equality Act, had to take place, the actions had to take place in it had to be unwanted. So the person receiving, on the receiving end, it had to kind of be clear that the person did not want this communication. And what happens with the Equality Act in 2020 is that this is taken out. And I think that's a very important step to recognize that sexual harassment is the act of the person who harasses, not the person who is harassed. Nevertheless, that we don't have a lot of cases that kind of can highlight the way that this has actually been in kind of to see the true outcome of this. So I wanted to, I wanted to talk about a few cases that we have had go through the court system. And I know that we are talking about administrative law, but bear with me. The reason is that in the very few cases that we have had gone through the legal system, and they are remarkably few, we have 2 cases, for example, that explore the connection between the criminal and the administrative law. And what I think is that there is a tendency that has now been framed here as a criminal justice drift. I thought that was a really clever concept. And in this case that I wanted to talk about, this maybe is the problem. So this is a 2017 Supreme Court case. There is a woman who is disabled who uses the services of travel services provided by the council. And the driver harasses her sexually. And this goes on for quite a while and takes place during his work hours. So this is workplace harassment, without any doubt. But what happens is that the case is prosecuted under the criminal standard, not under the administrative standard. Her testimony is deemed unreliable and not taken into account sufficiently her disability, so that somehow kind of it counters the importance of her or the recognition of her testimony, and he is acquitted. And I think this is a really good example of how we sometimes need to think about the administrative route rather than the criminal route. Because it is no doubt in my mind that even before the law was amended, this case would have been won on the grounds of the Equality Act, whilst it clearly failed under the criminal standard. We have another case that is a little bit older. It's from 2013, that happens in a gas station. And this is a man who is a police officer, and an attendant at the gas station who is a woman. They have had former some sort of on and off relationship, and he comes into the station dressed as a police officer at work. He is filling up the tank of the police car, and they engage in some sort of flirtatious communication. She does not, that does not sit well with her, and she takes the case forward and presses charges for sexual harassment. And to everyone's surprise here, the case ended with a not guilty finding, even though there was a video that had both audio and you could both hear and see what happened between them. But what is extremely I'm trying to find the right word, interesting, is that in the court's assessment, while assessing what is sexual harassment, the court looks to the Gender Equality Act on the substantive assessment of what constitutes sexual harassment while they are applying the criminal standard. And this, of course, is at least confusing to someone who is trying to see some sort of sense out of the criminal findings. So this, and what kind of what was the major point in the court's assessment was the prior relationship between the two. So that they had a history of flirtatious communication, they had a history of some sort of sexual communication, and in light of that, they could not go with her feeling of being violated, but they went with his understanding of this communication being banter as usual. So these are just two cases to highlight how the criminal standard and the administrative standard are actually conflicted in the court's assessment of the two standards. No. Okay.
I have proof here.
Yes. Okay. Okay, I need to rethink a little bit here. Okay, so okay, so when we talk about no, it's my fault. It's because I don't have the slides, so I'll blame it on something else, not myself. So when we talk about the administrative standard, when we talk specifically about the Equality Act, we have very few cases from the courts that actually kind of go on whether or not something is sexual harassment under the Equality Act or former Gender Equality Act. What we have is at least 3 cases of men that have been let go from their work because they were involved in sexual harassment at the workplace. So, or at least alleged that they were. So the kind of the guidance that we have about the administrative law is mostly dependent on how the work relationship or the contractual relationship between the person who performed the act and their workplace was, and whether or not the workplace could let him go because of what he did at work. So this, of course, is important. It's very important, but it's also a very good example of silence screaming, because the case law being so lacking shows us that this is a legislation or a legal route that is hardly used, and that is surprising, at least from a legal perspective. What I want to say in the shortest term possible is that the cases that we have seen regarding sexual harassment in the workplace, they show us that the main focus is on whether or not the process of that is described through the Workplace Regulation and the Gender Equality Act is followed. Nothing to do with the outcome. It is all about whether or not the process is followed. This is, of course, a very legal approach, trusting the process in producing the right outcome. But we also see that the courts have been somewhat flaky in whether or not these are binding to follow or not. So, for example, in a very recent case, probably the biggest Me Too followed case that has gone to the courts, is the courts have changed their minds in every single instance, ending up with the court being of the opinion that the Supreme Court being of the opinion that the procedure must be followed. And should that not be followed, then the person's contract could not be terminated as easily as it would have otherwise. Okay. So, finally, the last thing that I want to say is the advent of corporate social responsibility. What we have seen in the most recent and the most high-profile Me Too cases in Iceland is that the decisions that have been made, the letting go of the perpetrators, has been mostly taken on a business decision ground rather than a legal ground. And I find that from a legal perspective very interesting, to say the least, that the reputational risk of a company is what the boards found the decisions on, rather than using the process that we have described in the legislation. I'm done. Thank you.
Thank you.